Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce Podcast. I'm Scott Trout, Managing Partner and CEO of Cordell and Cordell. And today, great topic to talk about because I think sometimes we focus a lot on what does the law provide, what can I do within the bounds of the law, whether it be child support, custody, spousal support, property division, does misconduct matter? We focus a lot on the law. And today we're going to talk a little bit about really what's, I think, overlooked is how to behave and prepare for a cross-examination. And we're joined by one of the Cordell and Cordell attorneys in Knoxville, Tennessee. Welcome, John, back to the program and the podcast.
Thanks for having me.
So great topic. We were just saying, I said that off air, but how to behave. I mean, I think it's so critical. If a client's not asking you a number of questions, when, what, how, if, that, you need to bring it up. And I think a lot of attorneys don't do a really good job of preparing their client for what they should expect and how, what they look like, what they behave. And let's start right then and there. I've got court tomorrow at 9 a.m. What's the first thing we want to remind them about?
Well, I always want to remind people to be on time. That what I always explain to clients is that this is your first impression in front of the judge a lot of times. So if you arrive late and your attorney is having to make an excuse as to why you're late, the judge is going to take it as that you don't think that this is that important and that we're on your schedule. And regardless of whether the judge is late, you need to be there early no matter what. That's my number.
100%. I use this saying, and I'm not taking credit for it because I definitely didn't create it, but early is on time is late, and late is unacceptable. Exactly. And so the point is that you're right. Judges, it doesn't matter. I remember when I opened up our Atlanta, Georgia office, traffic in Atlanta is absolutely terrible. And to go 10 miles could take you 75 minutes. And there was an accident and I was late for court, not the client. And the judge looked at me and basically said that you should have anticipated there would be an accident and left at 5 a.m. I don't care what happens. I don't care if an earthquake happens. You arrive in my courtroom early. And I won't forget it, and so leave yourself time for error, for something bad to happen, because it is the most important thing of the day. So I think that's huge. So next thing is really, how do you look? Interestingly, I think COVID twisted reality when it comes to that. And mistakenly, I've seen, the lawyers dressing differently, which is shocking. I always tell the story. I was in a settlement conference via Zoom, and the lawyer shows up on screen in bed in pajamas. And I thought, no, you're I'm being punked here, right? Because there's some decorum and level. It is to show respect, and the judge went crazy. And same thing goes for clients, right? And it doesn't mean everyone has to dress exactly the same, but dress is important, right?
Right. So I never request that my clients wear suits. Some want to, but really my go-to is just kind of your Sunday's best. We're looking for a collared shirt for men, no loud designs, khaki pants if you have them. Jeans are also appropriate, but no courtroom is going to allow you to wear shorts and sandals to court. It just doesn't work that way. So for females, it's all about that collared shirt. Whatever you can pull together is going to be, okay.
Yeah. It's like, also no chewing gum, no baseball hats, right? And
right.
There's things that annoy the judge, and they are your jury. And so we want to do nothing to upset the judge. I've had clients, and I've instructed like you just did, hey, collared shirt. I had a client, despite my repeated instructions, he was a laid off CEO. And so he decided to come to court wearing what he would wear to mow the lawn in an effort to try to dress himself down and look like he was unemployable. And the judge read right through it. And I just, nothing I could do at that point. I kind of had a suspicion he was going to try to play the judge. Let's just not go there. You're never going to win. in terms of trying to under or over, or pretend. Judges see this every day and they can see right through it. So I think that's so key. It is be you. Don't try to be someone else. That's huge.
Yep.
So
we're here in the South in Tennessee, and I always tell my clients that this is not the judge's first rodeo. They know what they're doing.
Exactly. Or I always say when I was in Georgia, the attorney made an objection, that dog won't hunt. And the same thing. And I was thinking, that is a new objection for me, but I get it. So, all right, let's transition to how to handle cross-examination, because I get it. You're nervous, you're anxious. This is hopefully new territory for our clients. They don't know what to expect. It's so first really thing, what should they be thinking about when they're on the stand? And this probably could go for even depositions too, but anytime they're providing any testimony, what should they first think about?
Well, I think it's important to distinguish between direct testimony and cross-examination testimony. When we ask direct examination questions, it's us asking our clients questions, and we can't lead them. So we can't say, isn't it true that you went to the grocery store that day? They don't allow that. So when opposing counsel is cross-examining, they can lead you to that. They're trying to box you in with your answers, but they're also trying to get you to elaborate. It's kind of a complicated situation. So I always advise clients, only answer the question that you're asked. Take your time. Oftentimes I tell them to, pat your leg 3 times so you can really understand the question and then answer it. But if you answer the question and then opposing counsel doesn't say anything, you can be okay with silence. They're trying to get you to elaborate and run yourself into trouble. So that's one of the key points.
Silence is so important, and they're afraid that silence is so harmful. There is, and I don't know if you've seen John, but there's a Bill Barr, I think, Attorney General, the former Attorney General, William Barr, master at silence and how to deal with it. And he does it for a number of reasons. And I think he's spectacular. If you ever watch his testimony before Congress, and I would encourage people listening to this, go pull up his testimony before Congress and how he deals with not only the question by taking his time, but how he deals with silence. He sits there and he does it for 2 reasons. One, he knows he's on the clock, and these senators or congressmen only have so much time to ask questions of him. We may be under a time constraint in court too, in terms of you have an hour for cross-examination. He sits there. But it also allows him to really gather his thoughts, not react on emotion, but to give a very clear, cogent, well thought out answer. And it's okay to sit there and go, And, if opposing counsel says, did you understand my question? Oh, absolutely. I'm trying to give it some thought here and make sure that I answer truthfully. And I want to make, and clearly and completely. It's okay. But William Barr, I think, is so good at it. And I noticed it. And he's testified a number of times, and it's crazy that people don't see what he's doing, because it's so intentional, it's so good.
Right.
But then, leads us into how questions are asked of our clients. Be very careful, because the form of the question may be different, right?
Right. A lot of times with these cross-examinations, they're trying to lead you to an answer, and it goes back to that silence where they leave you sitting there thinking about the question, hoping that you're going to give more information that wasn't asked and may not be available to that attorney. Yeah. So what I always tell people is that when you're asked the question, pause for a minute, because your attorney may object to it, due to the rules of evidence or the rules of civil procedure, so that you're not required to answer. But the judge has to make that determination. So if you immediately jump into it, you may say something that the opposing party had no idea about, and now we have busted open the case, so that now you're dealing with issues you wouldn't have been dealing with.
Yeah, I tell clients, if I ask you your date of birth, you don't say January 1st, 1900, and I was born in Kansas City, Missouri, and it was a Thursday, and it was sunny out. I asked you what your birthday was. That's it.
Right.
Exactly. Your job is to answer only what is asked, period, and make them dig for more information. Don't offer it up on a silver platter. And I think clients sometimes they look at this maybe as not a game, but a challenge. So, and they fear the truth, and they fear that if they're not truthful, then that helps them. But the point is, if properly prepared and the clients are properly direct with you and give you all the bad facts, honesty is your best friend, right?
Exactly. I mean, taking the high road is the best way to go in litigation, and proper preparation will ensure that this doesn't happen. Of course, we always meet with our clients for several hours before any sort of hearing to talk about what could happen. But what attorneys hate more than anything is going to court and getting surprised by something because you didn't tell us about confidential information that you're either embarrassed about or that you know will hurt your case. We want to know everything. That way we can protect you.
Yeah. You know, backing up to taking your time, it allows your attorney, and that's part of it, obviously, is to object. There are some legal bases sometimes to object. It could be the form of the question. It could be an appropriate question. It could ask for what we call a lot as hearsay. With the federal rules of evidence prohibit such testimony. It may. And don't be in a hurry to answer. It's not a contest of how quickly we can get out of there, albeit I get it. If I'm on the stand, I don't want to be on the stand longer than I have to. Right. But let your attorney do their job, right?
Exactly. And, a lot of times in these situations, people get nervous and it may not even be intentional, but they suddenly are, giggling when they answer a question, or they decide that, hey, I'm going to try to get a laugh from the judge. Maybe that'll get them on my side. But that is not the time to practice your stand-up routine. This is a serious situation. And when you treat it that way, it's going to go a long way. This is all about first impressions, second impressions, third impressions. We want the judge to know that you're taking this seriously and that, this is not a joke to you, especially if you've got minor children involved or anything like that.
I was thinking when we were talking about honesty, one of my pet peeves is, and it's by accident, and I've caught myself early in my career saying it, when I would answer a question by saying, well, to be honest, blah, 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 blah. It implies that you're not honest sometimes, but only on this occasion, I'm going to be honest. So when we talk about honesty, try to strike that from your vernacular. It's fodder, it's add-on, it's puffery. You don't need it. It may send the wrong message, but part of that, as we get to, is don't guess. Right? We don't want to guess in our testimony.
Exactly. You're only going to want to answer the question that you're asked. If you don't know the answer, there's no problem in the world with saying, I don't know.
Yeah.
Valid answer.
Huge. And it is okay. And then, really, if you're confused, and I tell my clients, if you're confused or you need more time, you want to ask for that question to be repeated.
Of course. And there are a lot of times where that happens. And, you don't want to give an answer to a question that you don't understand and, give them more information. A lot of times in these situations, it depends on, the style of the attorney. But they will often, either be very aggressive with you or be very friendly. I always tell clients that they are not your friends. They're trying to trick you so that you give more information and that their side wins. This is not a chummy situation.
There's so much into preparation. I talk about in many of my podcasts, and representing guys is about preparation, but also appearance. And that appearance means what do you look like? What do you dress like? How do you act? How do you speak? How do you present to the judge? And not joking around. Or when I did jury trial work early in my career, I had a witness take his glasses off and chew on them as if, and it was almost, and the judge said something to me in the break that it was like an air of superiority. And so it is about how you look. Are you genuine? Are you sincere? Is it not calculated and rehearsed? That's right. Part of that. But I think most importantly, I've many times said that marriage is interesting. And when you do divorce, because I've had an opportunity, I was a prosecutor, I did big employment defense work for large corporations. And then I've been doing family law for many, many years, over 20 years now. I'm in my 31st year of practice, but is that the dynamic is interesting. You have to think about this. When you get married, your wife is sitting next to you at the table on the same side, and you have everyone else out on the other side, and it's a celebration. But now you have to look at this, and that your wife is now on the opposite side of the table, along with her attorney. They are not your friend. They are not there to help.
Exactly. And to harp on this again, when you've got minor children involved, that's when emotions really start getting escalated, and that's when things get nasty. So remembering that, you all are against each other in this is a huge thing. This is not time to suddenly consider reconciliation when you're going through a contested divorce hearing, So I just try to remind them that, even if the opposing counsel is aggressive, we don't want to argue with them. If they're friendly, you don't want to be chummy with them, because it all comes to the end. They're still your enemy, no matter what.
And there's some keywords, I mentioned, to be honest, but some other keywords are, I don't like the words, or very rarely should the client use the words on the stand-up. Absolutely. Always. 100%. Of course, that's all I know. Never. Because it puts you in a position that may come back to bite you.
Yeah, I mean, you're boxing yourself in. Then later on, the opposing counsel is going to use that answer against you and say, well, you said that previously. Why are you saying that now? They're trying to cut your veracity in front of the judge. So it's always just important to answer only what you know. Don't box yourself in, and don't elaborate for no reason.
Yeah, absolutely. And last, I think, is, and it's easy to get into this pitfall because you're in a very, I guess, emotional, period in terms of in state, and you're nervous and you're angry and you want it over and you feel like you're being attacked on the stand. And, a lot of people's natural reaction, it's either fight or flight. Exactly. You don't want to get in either mode. You want to be in just solid mode, and fighting is very dangerous on the stand.
Yes. I mean, the opposing counsel has been trained to do this. Our clients have not gone to law school, have not passed the bar. What really it boils down to is that you need to trust your attorney to protect you and to do the same to the other side, in all honesty. Yeah, it's going to be a fair fight.
Yeah, I'm pushing buttons. I want to rise out of the other side, and that is what I'm trying to push. And I mean, I'll go maximum. And one time, I always remember this, and there was a guardian ad litem in my case, and we were accusing the mom of using drugs, cocaine. Mm-hmm. And I kept pushing, and we took a break, and the guardian's like, look, I think you've gone far enough. I'm like, no, I haven't even started. He's like, don't do it. I kept pressing, and I hit it hard. And she finally on the stand looked at the judge, said, yes, fine. I used cocaine today in the bathroom, just because she was so tired of it. And there was and I just was like, it's like that moment with Tom Cruise where, that movie, I can't remember, A Few Good Men or something. Yeah. It was like that moment for me. And I said, that's all I have. And it was it. It was a
mic drop.
Right. And they're trying to get something, especially if anger management is an issue in your case. Mm-hmm. You cannot afford to go there. You got to, if you need a break, or, stab yourself with a pen in the thigh to get yourself out of it, that's what you do.
Right. And the opposing party knows you well. You were married at one point. And if you have a temper, they know it. And they're going to tell their attorney, hey, he really hates it when I do this. And they're going to go and hit that exact button over and over and over.
Yeah. Well, in 15 minutes, we've done this. There's so much more to preparation and kind of getting people prepared for it. It's like surgery. Doctors try to walk you through the process. Here's what's going to happen. You're going to do this, and here's what this medicine is, and here's what this machine means. And it's all designed to ensure it goes according to plan. And so that you're calm. And that's what we're trying to do. We could go on for an hour on this, but John, great stuff today. I'm sure there's more, and people want to reach out to you. They will, and I'll give you information on that. But thanks again for joining, John.
Thank you so much for having me. You have a nice day.
Thanks. Go to CordellCordell.com. You can give us a call at 866-DADS-LAW. But if you need to schedule a consult, especially in Knoxville or any of our Tennessee locations, or anywhere around the country where we have an office, you can go to CordellCordell.com. You can put your zip code or your city. It'll pop up the closest offices to you, and you can schedule online without even picking up the phone and get a consult, because that's the only place for legal advice. This isn't legal advice because we don't know the facts of your case. So we just want to provide you some education, some tips, then to kind of further educate you in the process and just fill you with information. So go to our website, check out our YouTube channel, which has all of our virtual town halls and podcasts. And if you haven't subscribed, do that now. You'll get alerted every time we do a podcast. So have a great week. And until next time, see you then.